Thank you, Your Honor. Your Honor, the state would note we oppose the defendant's motion for judicial release. The defendant was sentenced to a total of 4 years, 11 months, and it was a joint recommended sentence. Both the state and the defendant agreed that was an appropriate sentence for his convictions for disseminating matter harmful to juveniles, 2 counts of complicity to pandering obscenity involving a minor, 1 count of pandering obscenity involving a minor. To release the defendant early after serving just 2.5 years of this prison sentence would demean the seriousness of the defendant's conduct in this offense. Plus, given the fact that this is the defendant's 3rd conviction and 3rd time in prison, and his prior convictions were one for a GSI, which was a rape offense, pled down to a GSI, and then for another conviction for rape. So this was his 3rd sexually oriented offense conviction. The defendant is clearly a sexual predator, as shown by the defendant's conduct in this case. He was on parole when he committed the offenses. He was searching the internet for young girls. In this case, the girls he finally connected with were 10 and 13. The defendant was claiming to be 16. The defendant sought these young girls and had a written script that he used to talk to the children to encourage them to talk about sex, and then send explicit photos to him, and he would send explicit photos to them. The clear purpose of his contact was to groom these children for sexual activity. While on the parole, the defendant was living at home with his parents. He was to have no contact with minors without the consent of parole. He was required to notify parole of any internet access that he had. This was because parole has the ability to monitor his internet access. They can link in and see what he's doing on the internet. He failed to allow them to notify them of his contact on the internet. He failed to notify them that he had multiple phones that he was trying to have. He was required to attend sex offender treatment, and he violated all these rules while on parole. Much like his behavior in prison, where he's had at least 5 infractions in the 2.5 years that he's been there, the defendant appears not to believe rules apply to him. The defendant's proposal for early release is much the same as when he was on parole. He's going to live at home. He won't have cell phones or computers, even though he secretly did. He won't have contact with children, which he does, or he did. He'll attend sex offender treatment. And again, as Albert Einstein stated, doing the same thing again and expecting a different result is insanity.
Your Honor, I'll add that on the prior offense, as the court's aware, Mr. Reineke was on parole for that prior offense, and unfortunately this instant offense happened while he was on parole. The prosecutor would like to argue that the most appropriate thing in this matter would be to essentially go through the same process again and hope for a different result than what had happened before. I believe it would be appropriate, though, Your Honor, to actually work community control sanctions through this court. I think with the supervision that would happen through there, we have a better likelihood of having a successful outcome this time than letting the remainder of the jail sentence go through.
Mr. Reineke?
Yes.
Both the attorneys took the logical approach, and their arguments are expected, none of which means you're going to be either what they suggest. You don't have to be compliant, as Mr. Kelly suggests. You don't have to be a repeat offender again, as Mrs. Quigley suggests. The question is whether you can make any improvement, having spent 33 months in prison and jail, with 26 months still left in the balance. Don't make me any promises that you can't keep, and nobody can. So anytime there's a judicial release granted, there's always the risk that people reoffend. In one respect, you could say there was some progress made because his prior offenses were violent, and the legislature doesn't classify these offenses as violent conduct. So if the court wanted to take that fact, you could say that you did make some progress as you started to mature. It's still illegal. It's not to be condoned. The behavior's gross and unacceptable. the perspective of community control sanctions is not to give you a pass, but to give you a different kind of sanction, a different kind of supervision. So no, you're not in prison, you're in a less expensive environment where you're expected to do more than have 3 hots and a cots and not hassle the staff. So the purpose here is to see whether you learned anything, whether you can be productive. Twice the legislature's expanded the judicial release statute and tried to call on cases like this where there's a certain amount of risk taken to see if it can be productive. So we're going to take a chance at this. It's still consistent with the principles and purposes of sentencing for non-violent offenses to impose a community control sanction, even though 2 of them are F2 offenses. So I'm going to approve the motion for judicial release, place you on supervision for a period of 5 years,